Dan Goulding is an attorney with Quality Loan Service Corporation. This corporation regularly loses lawsuits in the state of Washington, and if I have my way, they're going to start losing lawsuits here in California. First of all, Mr. Goulding, who lives in this lovely house in the San Diego area, has worked for Quality Loan Service Corporation for most of this foreclosure period. I've reached out to some of his neighbors and I'm hoping that they give me more information about him, and especially if he's involved in any sort of criminal activity. Now, it appears he may have a side gig called Gone Golfing, and I need your help to learn more about that. So, when I got my foreclosure notification, I contacted Mr. Goulding, and to be honest, I wasn't very cheery, not in my initial contact. And he mentioned that to me, and so I apologized, letting him know that this was just a very frustrating situation. Now, in our email back and forth, he wanted me to believe that he was a nice guy. And for a hot minute, I tried to believe it. But let's just start with this. Before he started foreclosing on innocent people, here is what he did to get himself suspended from the California Bar Association.
Daniel J. Goulding, 51, of El Cajon, was suspended for 2 years, stayed, placed on 2 years of probation, and was ordered to take the MPRE with 1 year. The order took effect May 9, 2009. While one of two partners at Withers and Goulding in San Diego, Goulding represented two trusts worth more than $16 million that held the assets of James Hervey Johnson, a noted atheist who died in 1988. Both Goulding and Withers provided legal advice and represented the trust and trustees from 1997 to 2000, collecting more than $2.9 million in fees. Goulding did more work than his partner on the account. In 2000, the California Attorney General charged both lawyers with collecting excessive fees. The trustees were charged with mismanaging the trust. In a 2004 settlement, Goulding agreed to refund $330,000 of the $480,000 Withers and Goulding had collected in unearned fees. He ultimately completed the restitution. He stipulated that he failed to promptly refund unearned fees.
Now, if that wasn't enough, Mr. Goulding mentioned to me that he was not going to argue whether or not Chase was honest to him with the information that they had provided that led him to send me a notice of sale or a sale date for my foreclosure. Even though I pointed out that Chase is completely deceiving everyone with regard to my mortgage, he expects me to look the other way. And when I say Chase, I mean their representative Select Portfolio Servicing. Now, I'm sure he doesn't like this topic because it caused a heated exchange between him and Chase in 2013. But here are some of the excerpts from the 179-page email trail that I read. And Mr. Goulding, I know that you're attempting to convince me that you're a nice guy, but come on. I do discovery for some major law firms in Los Angeles, and I have yet to see anything as disgusting as the emails and their blatancy of how callous you are about foreclosing on someone. And you think you and Quality are nice. Well, so do most sociopaths.
Another email from one-time suspended attorney Dan J. Goulding. Daniel J. Goulding. Andrew, on this Washington loan, we received a 5810 declaration in 2010 from Chase stating that the securitized trust was in possession of the original note. Copy attached. The acquisition of this type of declaration is required before can record a notice of sale. Once we received this declaration, a notice of sale was issued and recorded. The sale was never completed. The borrower has sued Quality, claiming that Quality breached their duty of good faith, as we allegedly advanced a foreclosure without confirming who held the note. Quality argued on a motion to dismiss that we don't need to personally investigate who holds the note if we get a 5810 declaration, as the statute says. We satisfy due diligence as to who holds the note if we get the 5810 sworn declaration. In denying the motion to dismiss on this issue, the court stated as follows: Defendant's assertion that the duty of good faith is satisfied by reliance on the beneficiary's declaration alone is not well taken. RCW, and this is a statute, unless the trustee has violated his or her duty under RCW, the trustee is entitled to rely on the beneficiary declaration. For some inexplicable reason, the court in Mickelson v. Chase Home Finance deleted it from its quotation of the statute the duty to exercise good faith before relying on the declaration. Furthermore, in Mickelson, it appears that the allegation was that the trustee failed to conduct an independent investigation. It is unclear whether the plaintiffs had expressed specific concerns to the trustee that the trustee declined to consider or investigate. In the case at bar, the motion to dismiss it brought CR 12-6B-66. The court finds the plaintiff's claim is one upon which relief could be granted. As a result, Quality needs to establish that we did not violate our duty of good faith and that we could rely on the 5810 declaration we received from Chase. In preparation for an MSJ, we contacted Chase, who has not been named in the litigation, and advised that we would need a sworn declaration that Chase has been in possession of the note, at least back to when the 5810 was executed in May 2nd, 2010. This is a message from Dan Goulding, and he's getting more and more desperate. So he says, Andrew, we are about to file an MSJ, that's a motion for summary judgment, and would like to get something from Chase supporting that Chase still holds the note. Was it found? It was not found. If it was not found, possibly we can get a declaration attesting to how and when it was misplaced. Now, that statement comes with a wink wink, because that means go ahead and fabricate a document. We can potentially buttress this with something from the law firm that Chase had hired and who had the note and then sent it back to Chase. Your time and help would be appreciated, as we are concerned that we have an overly sympathetic borrower-friendly judge on this one. Borrower-friendly. Dan, what if you were the borrower? Would you want the judge to be friendly? I'm a borrower, and I hope I get a borrower-friendly judge. Anyway, Daniel J. Goulding, Esquire, General Counsel, formerly suspended by the bar. Another email from recently having been suspended attorney Dan J. Goulding, or Daniel Goulding, or Daniel J. Goulding. Andrew, tentatively this is good news. We will check with the Washington office of McCarthy and McCarthy and Holthus, but we doubt that they have the note, as they have been defending us on this action and had inquired of Chase as to the location of the original note. Maybe we will get lucky. Maybe we will get lucky. Dan Goulding, really? Maybe we will get lucky so we can foreclose on these people. Yay! Now, unfortunately, we don't have this full email. But it says that we have received from Chase and that we might get in the future from Chase on all foreclosure referrals. We would hope that Chase can locate the original wet signature note on this loan. But if not, we would hope that Chase can confirm that in 2010 that Chase did have the note and it was placed sometime thereafter. Wink wink. I felt it prudent to escalate this issue to you. Any help you can provide would be appreciated.
There you have it. Do you really think that the things that you were saying in that email trail make you seem like a nice guy? First, you were upset that Chase could not provide you with the note. Then you created a declaration, or rather attorneys for Chase created a declaration with your guidance, and then they found something akin to the original note. And this was probably a manufactured document which Chase has become notorious for creating. So, Mr. Nice Guy, you over the years have actually helped the servicers refine the way to defraud the homeowner. It must be nice to take a profit from from stealing people's homes. People's homes like this one that you live in. Now let's get back to mine. I have told you that my loan does not exist in the WAMU pass-through account that you are basing your entire foreclosure action against me on, despite your suggestion that it is not the trustee's responsibility. It absolutely is. Listen to this from the same documents.
This is actually a quotation from another Washington State loan or court case, and it says Quality has processed non judicial foreclosures of loans that have been securitized for many years. Its employees are generally aware of the documents reflecting the securitization, and servicing of a securitized loan are available on the SEC website. Quality employees, including myself, accessed and reviewed various securitization documents, including trusts established by WAMU, such as the trust into which Wilson's loan was deposited. So, Dan, if your company does this for other loans, why won't you do it for my loan? Dan. With regard to the substitution of trustee, or SOT, SPS signed this as the attorney in fact for the current beneficiary, and the fact that it was not witnessed by the third party is of no moment, as it does not need to be witnessed.
You know what? Yeah, no. See, that's not gonna work.
As you should have seen, the SOT was notarized, so from the perspective, its signing was witness/verified. As stated below, Chase assigned your deed of trust to Deutsche Bank National Trust Company as trustee on behalf of the holders of the WAMU Mortgage Pass-Through Certificates, Series 2005-AR8, on whose behalf the current foreclosure is being advanced. SPS is the loan servicer for the current beneficiary.
Yeah, no.
My home, and I have alerted you to this fact, and you are simply not doing your due diligence to ensure that everything is in order. I can't even believe that you blatantly stated in an email to me that it was not your responsibility. Please read California's Covenant of Good Faith and Fair Dealing. You know, the good faith issue has lost you enough in Washington State. It's only a matter of time that looking the other way is no longer going to work here in California. In short, you're not a nice guy, Mr. Goulding. You're much like any other thug working for a criminal organization. Only people like El Chapo, they're actually accused of doing some nice things for their community. What have you done that's nice? Did you just go golfing? So if you have any information against Dan, and he goes by Daniel or Daniel J, send that to evidence@foreclosureconspirators.org. Thanks for watching.